Welcome to Employment Law This Week. I'm George Whipple. On January 9th, the Department of Labor released its final rule on worker classification under the FLSA. This rescinds and replaces the rule established under President Trump in 2021. The new rule marks a return to the six-factor analysis favored in the Obama administration and expands that previous test to allow for consideration of additional factors. Barring a federal court injunction or further action by the department, the new rule takes effect March 11th. The NLRB also revived an Obama-era standard last year with a final joint employer rule. Under the controversial new final rule, a company is a joint employer if it holds indirect control over an essential condition of employment, even if the control is not exercised. The House recently voted to repeal the rule, which will take effect in February. President Biden has said he will veto if the repeal passes the Senate. SpaceX sues the NLRB for violating the U.S. Constitution. SpaceX recently filed suit in Texas against the NLRB, accusing the agency of unconstitutional exercise of authority. This came days after the NLRB filed a complaint alleging the company unlawfully fired workers who wrote an open letter criticizing SpaceX founder Elon Musk. The suit argues that the NLRB administrative law judges and board members can only be dismissed for cause, not at will, and that this violates the Appointments Clause of the Constitution. All three of the stories we've covered today show deep disagreements about how much authority federal agencies wield. That's a question the Supreme Court is taking head-on this term. In two cases, the court is considering whether it should overturn or limit its 1984 Chevron decision. Chevron empowers courts to defer to agencies' reasonable interpretations of ambiguous statutes. If SCOTUS overrules it entirely, it would mean drastic changes to how the Congress writes statutes, how they are enforced by the executive branch, and how the courts review them. Comments from several justices during oral argument suggest that the court could instead require more stringent adherence to text. This would remove the issue of ambiguity and make deference irrelevant. That's it for this week. Thank you very much for watching, and we'll see you next time.